My name is Millicent and I am a future legal practitioner. Today I'll be presenting on the concept of unjustified enrichment. Have you ever been in a situation where you accidentally paid somebody double what you were supposed to pay them? Or have you ever made a mistake of paying somebody 10,000 instead of paying them 1,000 rand? And what happens if they decide they don't want to pay you back the money that they shouldn't have received? Well, the law will provide a remedy for you. Today, we'll discuss unjustified enrichment. We'll talk about what it is, what the remedies are, and also what types of situations you can find yourself or that apply to unjustified enrichment. Unjustified enrichment is when somebody's property or assets or wealth is transferred to another party, but is transferred without a legal cause. A legal cause is a valid reason that will be justifiable in law. For instance, perhaps there is a contract between the two parties that will justify one party transferring their assets or property to the other party because they have an agreement. They have agreed to actually have that transaction happen. But if it happens that you transfer your wealth or your assets or property to somebody else, but there's actually no agreement that you should be doing that because it was a mistake perhaps on your part or because it was fraudulently done, then that is unjustified enrichment. But also, there are requirements that must be met for us to determine if there would be an unjustified enrichment claim. The requirements are that there must be an enrichment. One party must be enriched. That party would most likely be the defendant. Then the plaintiff will be the party that has lost out on the money or the property, and they would be impoverished. The next aspect that is required is that there must be no legal cause for it, meaning there is no contract, there is no agreement, there's nothing that actually requires you to perform. And also, the enrichment of the defendant must be at the expense of the impoverishment of the plaintiff. So this means that the defendant would see an increase in their assets, or where they should have had a liability, their liability will be distinguished. That means they are gaining. And this gain is happening at the plaintiff's expense because that person should not have actually lost out on anything. But now they find themselves in this situation where they have performed, but then they should not. But then what is your remedy if it does happen that you find yourself in that situation? There are a number of remedies for you. The conditio in debiti is a remedy that you can use where you accidentally made a payment to somebody where you were not supposed to. I'll give you an example. Perhaps you have a debt and you're supposed to pay the creditor 10,000 rands at the end of the month. And it happens that perhaps your husband decides to pay the money for you and they pay the creditor 10,000. And then the creditor doesn't notice this EFT payment in the account and they require it from you. And then you decide to pay the 10,000 rands as well. So that means that your creditor has actually received 20,000. But 20,000 was never the agreement. You have now made an extra payment. You can use the conditio in debiti to claim back the other 10,000 that they shouldn't have received. There's also another situation where somebody might pay someone because they're trying to have a transaction that is illegal. In that case, the conditio in debiti is not the only remedy that is available. There is also the conditio obtepam vel aestam causam. This is something that you can use whenever there is a transaction that has happened as a result of an illegal transaction. Let's say you and your friend decide that you're going to steal some diamonds from somebody. Perhaps your friend has the connection and you give your friend 10,000 rands or maybe even 100,000 rand to be able to proceed with that sale. And after you have actually given your friend the money, the cops arrest your friend and they still have your money. What do you do now? Do you just lose the 10,000 rands? You're actually not supposed to receive that money back because this involves an illegal transaction. An illegal transaction is against public interest. You shouldn't actually receive the money. But That is because of the par delectum rule that says that the people that have behaved disgracefully should not receive their performance back. That would mean that your friend would get to lose that money as well, or they would get to keep it. You wouldn't be able to get it back. But the courts have indicated that wherever there is cause to actually make an exception and relax the par delectum rule, they can relax the par delectum rule. In the JB case, the court decided that although it was an illegal transaction that they were actually involved in, that the defendant was able to get, the plaintiff was able to get the money back from the friend who had received the money before they can actually continue with the illegal transaction. There are also other conditions that you can actually apply. But the law of contract and dialect does actually provide more remedies. Wherever there was a contract where you were supposed to perform and you actually performed, but later on you discover that the contract was actually null and void, you would be able to claim your money back through the conditio causa data non sequitur. That provides a remedy for you. This actually does happen in some cases, but in South African law, there are not a lot of cases that have actually made use of this remedy. Again, that is because the law of contract is widely developed and it provides sufficient remedy wherever a contract is involved. The sine causa, the conditio sine causa specialis is also another form of remedy that you can use wherever there was a performance that should not actually have happened, because now the performance should not, the reason for the performance has fallen away. You would be able to claim the money back. In terms of determining how to actually quantify the enrichment that has happened or the impoverishment that has happened, or for a person to receive the money back that they've received, the court will have to determine the quantum of the performance and the enrichment and the improvement. That means that impoverishment, that means that how much enrichment did the defendant receive and how much impoverishment did the plaintiff receive. If the plaintiff has a lesser amount than the defendant, they would then be granted the lesser amount. For instance, let's say that you actually paid 150,000 rands into an incorrect account. Perhaps you wanted to pay the money to your brother and you end up paying it over to a stranger. When the stranger receives the money, they decide that they're going to spend 10,000 rands on their household necessities. Things like groceries, perhaps their electricity bill or their internet connectivity bill, things that they would usually be able to spend money on a monthly basis. They're necessary expenses that they would have spent it on. Now they take the other 140,000 rands and they decide to buy a brand new car. Once that car has been bought, there is no 140,000 rands anymore. It will then be only the value of the vehicle that can be considered. The claim of the 10,000 rands that was spent on monthly expenses that the person would have spent on, that means that he has saved 10,000 rands because it's stuff that he usually uses. So he has been enriched with that 10,000 because now he gets to save his own 10,000 that he would have used. But now the 140,000, he bought a car that he wasn't planning to buy. So now this is something that you will not be able to get in its entire amount. You will only get the value of the vehicle at the point of the claim. It will not matter that you actually paid 140,000 that he spent on the car. What will matter is what is the value of the vehicle at that point. If you only discover this after they have already taken the vehicle from the car dealer and they've already used it, the value of the car would have already dropped. Perhaps by the time you institute the claim, the value of the car is only 120,000 rand. That would mean that the claim that you can get is the 10,000 plus the 120,000 rands only. That is all that the court would be able to grant you. In some cases, it also happens that that person might decide that they want to spend the money on things that are important. So when it comes to property, there are also issues that happen. Perhaps somebody that occupies your space. Let's say that you are leasing out your property to a tenant and the tenant decides that they want to repaint the unit. They decide that they want to change the door frames, perhaps maybe put aluminum frames and remove the old steel frames. And they decide that they want to put in a jacuzzi as well in the unit because it becomes, for them, it's something that they feel is necessary. When you terminate the lease, the tenant will now want to bring the claim for all the money that they have spent improving your property. There are different types of expenses that will then be classified. There are expenses that are necessary for the improvement and protection of the property. For instance, the painting will make the unit look nicer. That means that you would have obviously spent money painting at some point. But now this tenant has saved you money of painting by painting it on your behalf. And because now it looks nicer because it's repainted, you would be able to get a little more money for it if you were to get a new tenant to come and rent it out. When it comes to the door frames, if the aluminum frames provide more security than the steel frames, that means that that improvement was also something that is useful. Maybe not necessarily a necessity, but it is useful because it provides more security for you in that unit. And when it comes to the jacuzzi, that's something that the unit can actually exist without. It does not necessarily need the jacuzzi. So that is actually a luxury. For luxuries, it is not necessary for you to pay back the money for the luxuries. But in some cases, it might be required. For instance, if it was an actual pool, the pool is a luxury, but it does increase the value of the property. That means if you decided to sell the property, you could possibly be able to ask maybe even 50,000 more than what you would have asked for it before the pool was installed. So the luxury item actually increased and improved the value of the property. So when the court identifies what type of expenses that the plaintiff or the tenant can claim from you, the necessary expenses, the useful expenses, and wherever necessary, wherever it is acceptable or wherever it makes sense, even the luxury items would be claimed or would be added to the claim. There's also another option to a landowner, but this applies in cases of farms. Not usually in the urban areas. It has not yet been determined that it's applicable in the urban areas. But in the farms where you find that a big plot of land has been rented out to someone else and they spend a lot of money doing improvements and making it look nicer, there was an option of placards. That means that the owner can ask the tenant to remove all those improvements that they have made to the property and reinstate the property to the value that it was or to exactly what it was when they found it. I've seen that this also applies in commercial contracts. If you take up a space in a commercial contract and you fix it up, you put your shop fitting and you make it look nice, when you vacate that premises, the landlord wants you to reinstate the place and remove all your fittings, and so that they don't have anything that they can owe you for. But also in some contracts, they might indicate that you leave everything and it becomes their property. But then we're not talking about that extensively because our focus is unjustified enrichment. And when it comes to the placards, owners sometimes have found themselves in a situation where the tenant goes ahead without their permission and they make all these improvements that they cannot afford to pay them back for. So the owner has to have a remedy. And the placards was actually allowing them a remedy to tell the tenants to remove their improvements. But also, what happens to a plaintiff who actually spent the money? What if you were the tenant that stayed on the property and actually invested some of your funds to improve the property? What remedy do you have? In a case where you are a bona fide possessor, you would have remedy, or a bona fide occupier, you would have a remedy. For instance, if you actually made improvements to a property, and the owner now knows that you've made improvements to the property and is asking you to leave because perhaps they want to put in another tenant in the property, or the lease has terminated and they do not want to renew your lease. You can ask the owner for the money that you have paid, on the necessary items and on the useful items. And you can hold on to the property until they pay you back. That is called the right of retention. It is a retention lien. This remedy is also available to creditors and debtors. Creditors have a lien that they can hold against a debtor. They can hold on to their property until they have been able to pay them back every single cent that they owe them. There have been cases where a person borrows a vehicle from someone, it breaks down, and they take it into a garage or to a mechanic to fix it. But then they neglect to pay the mechanic. If the mechanic keeps the car and wait for the owner to come, they can keep the car until that money is actually paid, meaning that they also have a remedy. Although the contract was not entered into between the owner of the vehicle and the mechanic, but because the mechanic has actually spent money fixing up this vehicle and making it and putting it in a good place, it means that they can have a remedy. There is a case, though, however, where a contractor was hired to install a pool. When he went to install the pool, he installed it at the neighbor's house instead of the person that had actually contracted him, only to realize later that it was not the correct property where he had installed it. Now the question became, who has been enriched in this concept? Is it the person that receives the pool, the neighbor next door? Are they enriched? If so, how do they then compensate the contractor? The courts decided that the claim would not be between the contractor and the neighbor because there is no contract between the neighbor and the contractor. It will be between the person that contracted the pool installer and that contractor. So the claim that can be made, it's between the neighbors. They can then, the other neighbor that did not get the installation that they required can make the claim directly from the neighbor that received the installation. But the contractor can only claim what they have spent for their hard work, for their labor, for delivering the service from the person that actually initially contracted them to do the work. Now, obviously, this is a very awkward situation anybody would want to find themselves in because you ask for a service, you don't receive the service. Now you have to go through a legal process to try to get your money out from the process. But then the court has to provide remedy wherever these kind of situations occur. There are also other situations that involve contracts of employment. And apart from the contracts of service, there are contracts of employment where you find that an employer dismisses an employee in the middle of the month. And this employee must now get compensation for the part that they have worked. The courts have decided that although the employer has actually agreed to pay the employee for a full month's job or service, they must pay them pro rata for the number of months that they would have worked, regardless of whether it was them firing the employee because of misconduct or a breach of contract or whatever the case might be. They will still have a remedy. They cannot receive free services from an employee and expect that because the employee has done something that led to his dismissal, they should not pay them. They must still get their money. The same applies for a contractor that is working for the employer in a workspace. If they have rendered services to them, but before they can complete the services, the contract is terminated or falls away for whatever reason, they should be paid for the days or for the amount of work that they have done. Or actually, they should be paid for the contract price minus the amount that will be required for the completion of the work. There's also cases where somebody decides to manage the affairs of another person. This would be requiring somebody to act as an agent for the other party. Usually, this occurs in the absence and without the knowledge of the owner. Let's say, for instance, two neighbors that are farmers have cattle on their fields, and the other farmer is absent when one of his cows falls sick. and the other farmer decides that he's going to assist this cow and take it to a veterinarian or call the vet to come to them so that they can save this cow. And they will have to spend money for this to be done. And they're doing this with the intention of being able to claim back the money. Now, the neighbor that is helping is not acting in his own interest. He's acting in the interest of the neighbor who's absent, who's not there to see that his cow is sick. And also he's acting with the intention of receiving his money back. He is a gestio in this situation. He's the jester, and he's acting on behalf of the owner, who will be called the dominant. What is required in this situation is that it must be determined if the person that is acting as the agent, were they acting in the interest of the owner, and were they acting with the intention of assisting the owner. Did they have a mandate or did they not have a mandate to act? And also, do they have an intention to claim back whatever they have spent in assisting the owner? If they did act with an intention to assist, if they did act without the mandate of the owner, if they did act with the intention to claim the money back, then they will be able to institute an action for them to be able to remedy, to claim back the money or any expenses that they would have spent in managing the affairs of the other party. There are a number of situations that can lead people to find themselves spending money on things that they don't necessarily have to spend, and where they end up spending because they are either assisting somebody or because it was a mistake, as we have mentioned. An unjustified enrichment is a claim that is available in these conditions and circumstances that I have mentioned. And it is broad, and there will be other cases and other situations as well where it can be applied. And in South Africa, it is not a very broad field that is actually used, but wherever possible, the conditio indebiti is most likely the one to be used a lot. And the other cases, they're not very significant, but yes, the law has to be developed a bit more, and taking in consideration what the Constitution requires, that in developing the law, it has to consider the elements of the Constitution and the Bill of Rights in making sure that they don't only think about legislation only, but treat each and every case or all circumstances on their own merits and make a decision that would be applicable or that will be justifiable, justiciable for that particular case. Thank you.